Voting in general is something I hold near and dear to my heart. How did I start, or when did the legal bug bite me exactly?
A warm welcome to the Middlesex University Mooting Society's YouTube channel. As part of our YouTube channel series where we interview legal specialists, we are honored to have the inspiring Fatima Balfaqeeh with us. Fatima Balfaqeeh is a legal counsel, independent arbitrator, counsel mediator, managing director of RKAH Legal Consultancy, Abu Dhabi. She has a very rich experience in arbitration and moreover have bachelor's in law, finance and masters in international business. She's a problem solver and an analyst. She loves to constantly learn and is a firm believer of wanting to give back to the society. Thank you, Fatima, for accepting our invitation. And without further ado, let's start with the first question. One of the most frequently asked question to a law student is that if they actually wanted to pursue law in the first place, or have you always had this inclination towards this legal field and arbitration? Where did all of this begin?
First of all, I would like to thank you for the kind invitation, Ahlam, and thank Middlesex Mooting Society for this very kind opportunity. As you know, mooting in general is something I hold near and dear to my heart, and I hope the best of luck for the society at large. So how did I start, or when did the legal bug bite me exactly? I would say very early on. I was always very curious about law and legal aspect. I did not have the chance initially to study law due to at the time when I wanted to study it, it was in a different city in the UAE. I couldn't go, so I opted to study finance. But even throughout my studies and my work, I've always kept in touch with that legal sensibility. And finally, after I started getting serious about mediation and arbitration, I decided to go ahead and fully commit to the legal industry and study my bachelor in law and eventually qualify as a lawyer as well.
And that's so interesting because I happened to go to the LinkedIn profile and you had bachelor's in finance and law and you have master's in international business. So I was so inspired. I was like, wow, within a span of a couple of years, you've mastered so many skills. So it's interesting to know that your first option, although you wanted to, was
Yeah,
not law.
yeah,
But it's amazing that you were able to also study that.
yeah.
So
I was very fortunate that I had the support to do it. It was not an easy journey, as you know.
yeah.
Studying Bachelor of Law is not like the most easiest journey that you would take. But I have to say, when I studied it later in life, it was much more practical because I had the knowledge and I'm just fortifying it with the legal concepts and all of those things that we studied during the 4 years.
Yeah, definitely that degree in finance must have given a more corporate idea of how law works. So, moving on to the second question. Miss Fatima, in a recent interview, you had mentioned that you are a firm believer of using sustainable practices. And as 2023 is the year of sustainability itself, how have you encouraged the use of sustainable approach within arbitration?
Absolutely. So I would say my overview to sustainability is a little bit different. I don't believe sustainability is only not printing papers and then we say we're sustainable. It's a far larger concept, and I think sustaining business relationships and making sure that the economy keeps going as well. It's a part of sustainability. If we're speaking about arbitration, ways of me advocating for sustainability within arbitration is a reminding the parties that they are entitled to stay the proceeding in order to negotiate and or mediate a settlement, which is something I'm a firm believer of ARB and ARB, which is arbitration and then in the middle mediation and then completion of arbitration on the topics they did not accept. In addition, of course, to being a signatory within the Green Pledge, which is a very well-known international um, pledge to decrease the carbon footprint by decreasing traveling, making sure that we accept electronic bundles instead of printing them out. Very fortunately, most of the local in the UAE and international laws now allow and accept electronic signatures as well as a formal method of ratifying and signing an arbitral award. So, working within the ecosystem that is already laid down in the UAE and ensuring that we keep going and reminding the parties and reminding the tribunal members and myself with those green practices and to put them in action rather than only speak about them.
That's so interesting because, like you said, putting it in action is a different cost altogether because we can speak about it, and a lot of us do speak about it, but to actually incorporate that within your practices and as your daily lifestyle as well is a different course of action. And that's you've encouraged that within your arbitrators and within your panelists, which is very interesting to see. And the following question would be, as a 16-year-old veteran in arbitration, you have seen the growth of arbitration in UAE, especially in terms of the implementation. And after the implementation of the federal law number 2018, the arbitration, which like UAE's first standalone law on arbitration came forward with, what are some of the significant differences and changes that you've seen that has sort of redirected the course of arbitration within UAE?
So for sure, the federal law number 6 in 2018 was a very important piece of legislation within the UAE when it comes to arbitration. We were able to have a standalone law, federal law, that allowed unity and consistency in how both the courts, legislators, and the parties apply arbitration. Before, there were a few articles within the Civil Transaction Code that kind of addressed arbitration, but it was not as, I would say, comprehensive. In addition, you know that the UAE arbitration law is modeled after the UNICITRAL model law. So it also gave a good impact internationally that the UAE is serious about being an arbitration friendly jurisdiction. We've seen that we've seen a growth in the maturity of the arbitration industry within the UAE. We've seen a big influx of cases. We've seen a different as well level of engagement from international and regional arbitration center, such as the opening of the ICC case management office in ADGM and the opening of the Saudi Arbitration Center in Dubai in the IFC. And there's so much interest happening. And that is all thanks to that piece of legislation that kind of fortified the position of the UAE and especially of Dubai as a legitimate and strong arbitration seat. According to the Queen Mary questionnaire that they do or survey that they do annually, Dubai have as a seat, as an arbitration seat, have ranked number 10, which makes it the only Middle Eastern and Arab seat on the top 10 international seats, preferred international seats for arbitration. So I would say that that is direct result of law number 6 2018.
So you can see that major difference after this implementation of the 2000 number 6 2018 federal law, and most importantly a lot of international influence as well. Like I happen to have read a recent report where Dubai, I think, beat Hong Kong in terms of arbitration. I think came number 7, and that was
Yeah.
so interesting because after, I think, within a couple of years, Dubai has, or UAE has just shifted its entire focus and so much direction towards arbitration, which we'll touch upon in a later question. And you had also briefly touched about SCCA, and you're also the director of SCCA Dubai, the Saudi Center for Commercial Arbitration. So, what is an interesting difference you have noticed in the terms of way arbitration is practiced and implemented in UAE and Saudi Arabia?
So, as you know, Saudi Arabia is going through a major, I would say, development and an accelerated development when it comes to its legal ecosystem. They have recently codified their civil transaction law and system, which is a different approach from before, where all the cases were completely managed and applied under Sharia law. So I would say that Saudi Arabia now are taking very serious steps towards encouraging foreign investments and dealing with international parties and reassuring the international community that they too are an arbitration friendly jurisdiction. They have also their own arbitration law that they work by. The SCCA have been fully supported by the legislator and by government by mandating the arbitration clause and stipulating that the SCCA is the arbitration center that is appropriate for government contracts. So I see a lot of similarities to what the UAE went through before with what is happening right now with Saudi Arabia. There is still a lot of ad hoc cases in Saudi Arabia, and I think more and more we will see it going through a mix between, or a better balance between, ad hoc and institutional, led by SCCA's effort. With the UAE as well, we see that the UAE's environment keeps getting more and more stable in terms of cases, in terms of judgments happening through our court system when it comes to enforcement of arbitral awards. We see that the quality of practitioners here in the UAE as well is of a certain caliber. You would see that very much reflected in the level of attendees when it comes to, for example, Dubai Arbitration Week each year.
Yeah, and it's even more interesting because I think the SCCA Dubai held the first branch here, opened it here, right, in Dubai.
Yeah.
And so it's more of expansion and making it more international, which is the main aim, to make it arbitration more friendly to everyone in it.
Absolutely. And I would say the opening of the Saudi Arbitration Center in Dubai is only a testament to the importance of Dubai as a legitimate international arbitration seat. And opening it in DIFC also fortifies the position of DIFC and DIFC courts and all the efforts that the DIFC have done on an international level when it comes for advocating for a dual legal system here in the UAE and more emphasis on the arbitration.
Now that we've touched upon the growth of arbitration itself, so the DIFC 2022 report had confirmed the growth in the number of registered cases of arbitration within the DIFC. So, why do you think there has been this rise in demand for arbitration?
So, arbitration, it makes sense, especially for commercial entities and companies, that they would like to, be able to choose their judge, quote unquote, by assigning an arbitrator who has experience in the subject matter, maintain their confidentiality to ensure that the dispute is resolved under as much protection of confidentiality as possible, ensure that the award that is issued is also a final award, It is relatively, and I will put it under a very big emphasis that it's relatively fast, because some cases do take a longer time due to its complexity and the acceptance of both parties that they wanted to take more time. But a lot of also smaller claims and smaller cases are usually dealt with within 6 months, and that is the norm as well.
Definitely. I think even when law students learn about arbitration for the first time, the values and the qualities that we learn is the fact that it's cost efficient and it's speed. Because compared to a court process, it's just it's just shorter, and court processes tend to lag a long time. And that's one of the ways arbitration is pushed forward. And like you said, some cases have exceptions. But yes, that is definitely, I think, one of the very reasons why people opt arbitration. So now we get into a technical understanding of what an arbitration is. So, Ms. Fatima, could you tell me what the duties of the arbitrator is when they're first assigned to a case?
So we have to think about the duties of our arbitrator, and I will try to be as brief as possible because this in itself can be like a couple of hours. But if I touch upon the most important things, there are some behavioral duties that an arbitrator needs to maintain, and then there are some processes that the arbitrator needs to adhere to as well. So if we think about what the arbitrator needs to embody, they need to be independent, they need to be impartial, they need to be very upfront and transparent to the parties. If any conflict of interest arises from the beginning or throughout the proceeding, they need to immediately report on it and be able to, with all transparency, declare it to really protect the arbitral award at the end of the day. They need to be also knowledgeable, and they need to have some soft skills to be able to manage the process and the people who are participating in the process. Now, when we are speaking about the technical side of the arbitration, we need to ensure that the arbitrators, first of all, when they receive the arbitration file, that they review it in details, that they are diligent when it comes to reviewing the submissions, making sure that there is no requests filed within the submissions and they missed. They need to have very good time management. They need to understand the rules of the arbitral proceeding. They need to understand the law of the seat very well, and they need to be able to analyze the substantive law that is pertaining to this specific dispute. Of course, the process, it's more or less the same. You have to either, it depends on the rules, but you have to create some sort of a terms of reference, do the CMC, which is the conference, which is the case management conference meeting, and then decide if you want to be paper-based or some hearings are included. You need to, again, when I told you about the importance of understanding the seat, if you're in the UAE, you have to allow for a hearing to swear in the witnesses and expert witnesses, otherwise you jeopardize the final award. And finally, the skill that is the most important is the arbitrator needs to be fully aware how to write a sound, structured arbitral award and to be able to give it on time, basically, to the parties.
All right. So just a follow-up question on that. Is there any overlooked process which may be minimal but is vital, that is missed by some of the arbitrators, but it might actually turn the entire outcome of the case?
I think one of the things, especially when you get into the international arbitration scene, it is extremely important to not assume that you know the law of the seat, because all the laws of the different seats are modeled after the UNICITRAL model law. So it's easy to kind of assume that you understand it, but you need to go back and actually examine the law of the seat very well, because sometimes there's something that is a public policy issue, and it can jeopardize your award to be set aside. Same thing can go with understanding the substantive law, that you're not judging in a way that you are again going against the public policy. Most of the setting aside motions that are brought forward to the courts, it's either a major issue with the process, or something that was, or a topic that was covered by the final award that was actually against public policy, and therefore it was grounds to set aside or annul the whole award. So I would say really going back and examining and not assuming that you're fully aware, and actually examining the law of the seat. That would be a very good step.
Yeah, to be thoroughly prepared as always, because arbitration itself is an intricate process. So
Absolutely.
there's a reason why people opt for it. So to make the best out of it, you should be knowledgeable, like you said.
Absolutely.
And you had in our conversation touched upon ad hoc and in institutional arbitration. I happen to have read about it, and it was interesting because there's a difference in between the difference of these methods and the methods that you choose to implement as well. How would you go about it?
So I think between like whether we opt for, if it's a general question, which is better, ad hoc or institutional. Institutional is more guaranteed to the parties and to the arbitrators themselves. It's a little bit more structured. There is the support of the back office of the institution. There is most of the institutions now have courts where they actually review the awards and make sure that there is nothing of a major concern when it comes to applying the law of the seat or the substantive law. Also, you as an arbitrator don't have to worry too much about the fees, to be honest, because the fees are paid to the
Institution.
center,
Okay.
yeah, rather than to you. When it comes to ad hoc, the answer would widely vary depending on the seat. So, for example, if the seat is in the UK Arbitration Act is quite detailed in a way that it allows you as an arbitrator to have a very specific methodology and procedure to carry out the arbitral proceeding. But I would say a lot of of the laws of the seats are have certain level of flexibility, let's say, to allow for institutions to operate within. So I would always say to just kind of guarantee the outcome institutional is best, but we cannot deny that ad hoc is there. So in the case that you get an ad hoc, you as an arbitrator become the arbitrator and the institution. So you really have to be very diligent, very careful. You have to collect the amounts of the fees. You have to run the administrative side of the case, in addition to the procedural side of the case. You have to be extremely diligent in your terms of reference and mention everything and agree on everything. And you have to work twice as hard in an ad hoc case, simply because you need to supplement for the lack of availability of an institution to support you.
So, in terms of what the parties choose, what have you seen mostly? Have the parties or mostly gone for ad hoc method or institutional?
I think more and more we're seeing that the parties are going for institutional. However, ad hoc is either a result of a very poorly written arbitration clause, where they have completely missed the name of the rule of the center, or they have agreed an arbitration without stipulating anything else. So I would say whoever is gonna from the students and aspiring lawyers would go and choose a career that has to do with drafting arbitration clauses. Just be very careful about being extremely technical and diligent when you're writing it, because if you agree on an arbitration but you fumble on the institution name, it turns into an ad hoc arbitration. So yeah, and there are some but I see them dying down a little bit. There are some parties that choose ad hoc for several various reasons. And it really depends on the type of contract, type of arbitration and type of deal that we have going on. But yeah, definitely we see a rise in institutional rather than ad hoc.
That's very interesting. So, the next question is also surrounding arbitration in terms of if you're dealing with someone who is uncooperative or unwilling to participate in the arbitration process, how do you sort of make them cooperate with and make sure that they are in the process?
So we have certain levels of this. Okay. So it all starts by making sure, as an arbitrator, I make sure that the party, so the respondent usually is the one that is not really engaging. So when we see that the respondent is not engaging, we make sure, first of all, that they have been notified correctly. Okay? So the proper notice is issued and served, that there was not an issue in delivering the notice, that they're fully aware, and we exhaust all attempts to do so through the claimant, of course. The arbitrator cannot communicate directly with one of the parties or have an ex parte kind of communication. So you do it through the appropriate channels, whether it being through the claimant themselves, the center, or the courts in terms of ad hoc cases. The second thing, if we are fully aware that the respondent have been fully notified and they are well aware, we try to engage with them. We give them ample opportunity to present their case. But matter of the fact, there are some just very simply non-responding respondents. And most of the rules, laws of the seats, UNICITRAL rule, laws and rules allow for the arbitral tribunal to proceed with the case, even if there is a non-responsive respondent. If there is a case where the claimant have put the claim forward and they have indeed submitted their statement of claims and then chose to not respond for some weird reason, because it's not usually the case, then also the tribunal, under most arbitration laws of the seats and rules, is allowed to proceed. It depends, again, you need to go back and review the law of the seat and the rules. And that's when you need to be very diligent in order to kind of catch the nuances to it. But all what you can do as a tribunal is to give ample opportunity for a party to present their case, encourage them to do so, but otherwise you have all the authority to proceed in issuing their final award.
All right. So, moving on to the next question. So, what are some of the misconceptions you have seen the parties involved in arbitration have that you wish to change?
Yeah, so there's, of course, arbitration have gained some traction and knowledge within the parties, but I would say there are still some misconceptions about it. Some people think that it is far more expensive than what it is truly. Some people, or some not optimal behavior that we've seen, or that I've seen personally, is that the parties will come and treat the arbitral proceeding like it's a court hearing, where it's not necessarily a court hearing. And I think also we see, although it's also a dying kind of trend, that there are some guerrilla tactics that are still being used to kind of frustrate the proceeding. And that sometimes is not the most optimal situation.
Well, that must be so challenging because the whole point of arbitration in itself is to simplify the court process and to ensure that the parties resolve it peacefully. So it must be sometimes really frustrating or challenging to see the parties have a different outlook on, but it's understandable because a lot of them not really are exposed to law or legal field unless they actually come into practice or contact with it. And I think the most important question that I've been wanting to ask is you've inspired so many women to push past their limits and your achievements reflect this very message. If you could say a word of advice to aspiring lawyers, what could it be?
So I would say, well, thank you very much for your very kind words. And I always think that I do not think that as I'm doing what I'm doing, that I want to inspire anyone, but more of wanting to lead by example and showing what is possible for other women in the region. Um, I would say sometimes as women, especially, we hold ourselves back in terms of fears or worries about misconceptions or what is possible. I think the first thing that we need to kind of realize that, sometimes we put the limits for ourselves. So always ask yourself, where is this coming from, to kind of really fine tune where is this fear coming from in order to know how to tackle it. Second of all, as aspiring lawyers and as young lawyers, you need to make sure that you make yourself visible. You go out there, you network. You need to find a mentor, and you need to find not only one mentor, several mentors. Some of them inside the industry, some of them outside the industry, because even from outside the industry looking in, it can be very beneficial for you as a young lawyer. Do not shy away from working in volunteer position or in committees, because it gives you so much exposure, so much knowledge as well. And do not shy away from doing some grunt work, because at the end of the day, that grunt work, you will kind of relate to it later in life. Just be passionate about what you do. Really keep upskilling yourself, invest in your knowledge, invest in your skills. It's very important that you don't learn and then stop by finishing your bachelor. Take different programs, take different courses, listen to different there's so many resources online. Listen to different webinars, seminars. There are some leaders in the market that they are very generous with sharing their knowledge. I've learned personally from all of them. So just keep working on your skills and keep sharpening your tools, which is your knowledge and your personality in terms of presenting yourself. And know that the law, the legal field is such a vast field that you can choose to specialize in whatever tickles your fancy, whatever it is that you feel like you're passionate about, you can specialize in it. You can specialize in the media field, you can specialize in the sports field, you can specialize in construction, commercial, corporate governance, transactional lawyer, and whatever you feel like you can really give your utmost in, that's what you go ahead and specialize in. So yeah, these would be my pieces of advice.
I mean, I absolutely admire that confidence. And I happen to have listened to the Kelly Lundberg's podcast. and I was able to hear a lot more of personal experiences, which really was some things really resonated with me, which I would tell you after the interview. And it's amazing to see your growth and that perseverance to acquire more knowledge, and your want to learn more have definitely um, formed into who you are today. And we are so honored to have you on this panelists.
No, thank you, Ahlam. And I would really, whoever is interested in the field of arbitration, I would tell you the mooting experience is the key to not only gain knowledge, but also to get to meet different people. And now that we have different kind of course, we have the Vismut being the flagship. We also have mooting in Arabic that have been going and making waves through the scca, International Arabic Moot, that gives a conduit for especially bilingual people to truly practice in both languages and be equally as good. And again, as I told you, I am very honored and privileged to speak to you guys and be in this to be in this interview, and would really encourage everybody to believe in what they want to achieve and just persevere. The opportunities are a lot, but you need to kind of think outside the box a little bit to achieve them.
Definitely, being law, like you said, it's intimidating, and sometimes the vast options and the varieties that come at you all at once just makes you stand back and think about all together. Oh, have I got things all together, or am I still missing things out? But thank you so much, Fatima Balfaqeeh, for accepting our invitation and taking your valuable time to come and be our interviewee. Definitely, these valuable advices will be listened to by all the law students and a lot of viewers of the YouTube channel. And thank you once again.
Thank you. Thank you all. Thank you for the Middlesex Mooting Society.